Welcome to Daily Justice Files.
All right, court is calling 2022 CR 11882, State of Texas versus Ralph Perez. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Louis Martinez on behalf of Mr. Perez.
Are you Mr. Perez?
Yes, ma'am.
All right, have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections?
No, Judge.
No objections, Your Honor.
Have both parties had a chance to review the TAP evaluation?
Yes, Judge.
Any objections?
No, Judge.
Nothing from the state, Your Honor.
Any witnesses from either party?
No, Your
No
Honor.
witnesses from the state, Your Honor.
No, Your Honor.
All right, is there a reason I should follow this plea bargain agreement?
Counsel?
Judge, it's our plea bargain agreement, Judge. State and I both looked at this case, given the seriousness of the allegations, but the lack of corroborating evidence. After lengthy negotiations, we believe that 10 years deferred adjudication with lifetime registration is appropriate in this case, and that would allow the state to sufficiently supervise him for a long period of time. He's not eligible for early termination. He's not eligible for non-disclosure. So this isn't going away. And of course, if the court finds that he violates the terms of the probation at any point during this 10 years, the court can assess 20 years in prison. And Mr. Perez knows this. And so given those facts, Judge, we're asking the court to accept the plea bargain in this case.
All right, is there anything else from either side?
Nothing from the state, Your Honor.
All right, anything you wish to say?
No, ma'am.
All right. All right, this is what the court is going to do. The court will follow your agreement. The court is going to sentence you to 10 years deferred adjudication. There's to be 180 days in the Bexar County Jail as a condition of probation. Chapter 62 registration. There's to be no contact with the complainant. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days or SSI. There's to be no employment as a home health care provider or with minors. And you'll be under the sex offender unit supervision. There is no community service hours for me to give you because for offenses of this nature, there's nowhere to do community service hours. So I'm not going to impose community service hours. This is a second degree felony. What are the court costs? All right. What I can tell you is usually the court costs on the second degree felonies, usually they're about $380 to $450. Counsel, if there's any reason that your client cannot pay that, all you have to do is present an affidavit to that and the court will take care of that.
Yes. I do need to speak to the conditions quickly.
Yes.
So, Judge, our plea bargain, obviously, the court can impose reasonable conditions of probation. Our plea bargain did not contemplate time in jail as a condition. Mr. Perez is the caretaker for his two elderly parents. He does not have anybody else who lives with him. They do not have other arrangements set up. Would the court allow him to 30 days to prepare to make arrangements in order to do that? Because literally there's no one to take care of them at this point.
No. I mean, if somebody wants to bring me documentation of that, I'll reconsider. But for now, the answer is no.
And then because he's disabled, he's not working. So any house arrest, there would not be any request for a work release. There would be no request for partial. I just want the court to understand that we would not be making any of those requests if the court were to consider house arrest to allow him to take care of his parents.
All right.
Okay.
All right, Mr. Perez, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, and this does require registration, so make sure that you're registered. Otherwise, that could potentially be a new offense. Do you understand?
Yes, ma'am.
All right, good luck to you.
Your Honor, we have brief impact from both the complainant and her mother at whatever time the court would.
All right, I believe legally it's the complainant who gives victim impact unless the
For a minor
defense.
judge, that's the only reason.
Okay, unless the defense has no objection to the.
I would object to that, Judge.
All right, so the complainant, unless the complainant's parent has something they want to read that the complainant wrote, otherwise victim impact, it's the complainant.
Our understanding was that if it's the guardian and they're a minor, that allows that opportunity, but if we misunderstand, we're more than happy to just have the judge.
And Judge, one more question. So the fact that he's caretaker for his parents, his elderly parents, is substantiated in the PSI. What other type of documentation do I need to?
Oh, some type of medical documentation.
Okay.
All right. Okay, thank you.
What looked like a routine plea agreement was about to take an unexpected turn. Judge Boyd accepted the deal, but his next decision caught everyone in the courtroom off guard.
All right. Is there, and I understand the issues. Is there a reason why it can't be taken care of today?
And what would be the reason?
Well, because we basically just gave me an offer that we're not completely.
So do you need more time to confirm?
Yeah, sure. Yes.
Okay.
Yes, ma'am.
Sure.
I'm always curious.
It's a good way of putting it.
Yeah.
Those are beautiful flowers.
All right.
Those are beautiful flowers.
Oh, thank
Is it your
you.
birthday or?
Yeah, they're from Hawaii,
Oh, it's beautiful.
and I was surprised. I was like, oh,
Beautiful.
I think flowers always brighten a day, you know? All right. So Norma, in this case, is 30 days enough time for you?
You know, I say 30, that'd be July 4th-ish. I'm going to be, Judge, anytime I'm going to be going back home to Colorado, probably be back around the 10th or after that, if that's possible.
All right. Norma, can you set this the fourth week of July? Is that good?
Perfect, Judge.
Okay. Is the 23rd good?
Perfect, Judge.
Is the
Thank you.
23rd good for you?
Yes.
Is that going to
I
interfere
don't know
with it?
what day is that?
That's a Tuesday. Is that going to interfere with your treatment?
I actually have an appointment the next day, so maybe like a couple of days after that, that'll work out.
All right. So
23rd is good.
I told her maybe like the 27th. Is that?
the 27th is a Saturday.
Or so, then let's do the Friday or Monday.
Monday is the 22nd.
So Monday's the 27th. Okay.
July.
Planner with me. That's fine. I'm sorry.
Sure.
That's fine.
So do you want it on what is a good date for you? Because I know you have treatments and sometimes you're sick after treatments and you need recovery time.
Right. So I would say the Monday after, so would it be the 27th? So
So you're saying the 29th?
yes, that's better.
Do you have a calendar?
I
Yeah,
feel like
I have
this
a
is-
planner with me. I just
Yes.
have my planner with me.
All right. He's going to show you the calendar.
Let me show you.
Yeah, let me see.
So when is your appointment?
It's on July 24th, which is a
All right.
Wednesday.
So do you want to do it on the 22nd?
On the
Because I
Monday.
don't know,
Okay,
sometimes
yeah, let's do that. Let's
the
do it.
22nd?
Yes.
That's good, Judge.
All right. So we'll put it on the 22nd because I know sometimes after treatment, it takes a while to recover.
Sure.
So July 22nd, once you sign the reset form, you are excused.
Thank you,
Thank you
Judge.
so much.
All right, thank you.
Appreciate you.
All right, you're welcome.
All right.
So your case hasn't been indicted.
Okay.
You'll know if your case is indicted because the number you see will have a CR to it.
Okay.
So we don't have pre-indictment cases in this court unless your attorney requests it.
Okay.
All right, so you are excused. If there's an issue with your bondsman, you can ask the court. You can call us and we'll let them know you were here.
Thank you, Your Honor.
All right, thank you. Have a good day. James Jenkins. Hi, if you'll come forward. All right. Do you know if your case has been indicted yet or not?
No, it has not been indicted.
All right. So we only have indicted cases here. You know your case has been indicted if it has your number and a CR in it. So it'll say 2024 CR and then the number. So the only time you will be in this court is if you have a case that's been indicted or unless your attorney has specifically requested that you be in court today.
Well, yeah, but he went on his 52nd wedding anniversary today.
Okay.
But
Oh, well,
this the courtroom that they told me to come to.
All right.
I didn't get any paperwork in the mail or anything. I had to come down here and go to the clerk's office to find out all my information.
okay. All right. And do you have your correct address online?
Yes,
All right, listed so they can send you information?
yes.
Yes. So you don't need to be here unless it's been indicted or your attorney has requested you appear. Do you understand? All right. So you're excused. If there's an issue with your bondsman, you can always call the court and we'll let them know you were here. All right. Thank you. Have a good day. You too. All right, so where are we with regards to evaluations and everything?
Yes, Your Honor. This morning I went down to Judge Carruthers' court. He was set for informal inquiry. Judge Carruthers did this morning order a mental health evaluation to determine his level of competency, Judge.
All right, so what we'll do is we'll set this for, well, do you think that it's probably going to be incompetent, or you're not sure?
I'm leaning towards it possibly being more incompetent than not.
All right, so what I'll do is I'll set this for 90 days because I know with the nature of the offense, if he's deemed incompetent, they're probably going to send him to a facility, and that's going to take a time for transfer. I need a 90-day reset on Mr. Payne. All right, August 27th.
Yes, Judge.
All right, do you have any questions, Mr. Payne? All right, we'll see you back then. All right, thank you. All right, Anthony Cochran.
Good morning,
Good
Judge.
morning.
This morning I was told there was a misdemeanor that's recently been unsealed and filed out of the same incident. There's also several co-defendants. I conferred with the state. It's our first setting. We'd like respectfully to reset this for discovery and allow my client to be transported down to 2 where Judge Sines has agreed to magistrate him so we can get a bond set. He doesn't even have a bond.
Okay, were you recently appointed?
I believe
Because-
we've had a pre-indictment setting, but we haven't had it. I believe this is his first setting post-indictment in this case.
No. State, who is on Anthony Cochran?
Yes.
All right, we were here on April 30th. And so today, the state was to make an offer in discovery. Are we not at the stage of,
I didn't discuss that with defense counsel. I mean, I think
I was more worried about his warrant right now because it's a new thing that has popped up.
he has a warrant out of county court 2. And I think that's one thing that she was trying to get resolved before, because we haven't had a time to discuss. That's what she was.
all right. So do you have all of the discovery?
I have no idea if I have all of the discovery.
All right,
There's a
so
lot.
we're going to come back. We're coming back on June 17th.
Okay.
All right. They need a reset for June 17th on Cochran. Sure. Mariano Rendon. Hello, hi.
This is a co-defendant to Chicago's
Okay.
case, although this one, I was just talking to Mr. Willis about it. We believe, I gotta check with intake. I think that there may be 2 indictments, but for the same incident. And I gotta decide, find out if that's a dismissal on one or not, Judge.
Okay. To keep them together, I'll put it on the 17th, but I know there are going to be some issues.
And just so the court knows, I filed a notice of appearance on both of these cases. Mr. Molina was originally the attorney. I've talked to him. He was kind of in Comell County, but I filed notice of appearance, retained counsel on both. Mr. Molina was appointed.
All right. So we'll recall this back for June 17th.
Okay, good.
All right. If you'll get your reset form, then you're excused.
The attorneys believed the case was nearly over, but one request from the defense would quickly reveal that this hearing still had an important twist waiting to unfold.
All right. Is the court's understanding you are requesting a jury trial?
Yes, ma'am.
And you're rejecting the state's offer?
Yes, ma'am.
All right. Your plea deadline date has expired. State, how long do y'all both anticipate this case taking?
2 days.
One for
jury selection and one for
evidence. Yeah.
All right.
3 if you count deliberations, I guess. Right? We always underestimate.
Okay. So when is your jury trial date?
Next date is July 1st, the impact.
All right. Ms. Ferguson, you all want to put this on impact?
Yeah, we absolutely can do that. If that's okay with you, Judge.
Yes.
Counsel, of course, but that works with us if that works with y'all.
All right. Your jury trial date will be in impact court and it'll be July 1st.
Thank you, Judge.
Yes, ma'am. When we leave, I'll show her where impact court is.
All right. Thank you. Once you fill out the reset form, you're excused.
Yes, ma'am.
Thank you.
You're welcome. All right. Can I see the files on Loretta Holmes, please? All right. Who's the party on Edward Casillas?
We are, Judge.
All right. So defense, did you have a chance to provide mitigation?
Yes, Judge, we did that. And today the state has offered or has okayed us to apply for pretrial diversion. So my client and I went out and filled the application and we have turned it in this morning.
All right. I need a reset for PTD on Edward Casillas, please.
What began as a routine plea agreement quickly became something more. Both sides had agreed on the sentence, but in every courtroom the judge has the final authority. After reviewing the case, Judge Boyd accepted the agreement but added an unexpected 180 days in county jail, changing the tone of the entire hearing. The defense then asked for more time, explaining that the defendant cared for his elderly parents. However, without supporting medical documentation, the judge declined the request. This case is a reminder that in court personal circumstances can matter, but they must be supported by evidence. Do you think Judge Boyd made the right decision? Share your thoughts in the comments and subscribe for more real courtroom stories and legal insights.